Hi, this is Alan Gassman. I'm not quite on Clearwater Beach, but I wish I was driving that little vehicle on the left. It looks like a lot of fun. We're here today to talk about something that's even more fun, and that is the biggest mistakes that physicians make as owners and non-owners in medical practices. I've decided that we're going to do this as part one today on January 30 so I can get out to the beach, and we're going to do part two on February 27th, Thursday, February 27th. So hold on to your hats. Here we go in seconds flats. February 6th, please join John Beck of our firm on passive rental losses and how they work. On February 13, I'm going to be talking about part two of planning for Florida dental practices and their owners. If you want the materials from part one, please let me know. And then part three of success tips for first-year lawyers will be February 20, and February 27 will be part two of this presentation. Page 5, I'd like to know 3 things that you would like to get out of today's talk. One might be new planning techniques that you can use for your physician practice. A second, if you're not a physician, might be something you can communicate to your physician practices to let them know about something that's important. And number 3 might be half an hour of continuing education. If you're a CPA and you need half an hour of continuing education, let me know. Or if you'd rather just go back out to the beach, my little vehicle's gone. I saw some birds flying before, but there's no birds flying now. So let's go back to the presentation. The first thing I like to talk about when I speak to physician clients is what their personal goals are. And the really most important goals, number one, saving money for retirement. Doctors want to be financially independent, so saving money for retirement and knowing how much they need is really important. It makes them more comfortable in the practice setting. Number 2, having the right kind of life insurance. Number 3, having sufficient malpractice and liability insurance. That's very important. We'll talk more about it in a little while. Number 4, owning assets in an appropriate way so that they are immune from creditors. That needs to be on the checklist. It's something we always review with them. Number 5, having the medical practice coordinated with the creditor protection. And the list goes on, including number 11, having a good CPA, and number 12, having a good lawyer. I mean, let's face it, if you don't have reasonable goals, you're never going to get anywhere. That is for sure. If you fail to plan, then you are planning to fail, as a good friend of mine once said. Now, I have a speech type slide here on page 7 about the fantastic future of a physician. This is a presentation that I give often to first and second year physician groups and residents and fellows. Please do have some skepticism if you are a physician, and even if you're a physician advisor. Physicians are lied to and misled all the time. Sometimes they're misled indirectly. For example, if a bank will loan them enough money to buy a 10,000 square foot house and a Ferrari, they think that means that they can easily afford to have a 10,000 square foot house, a Ferrari, put their kids through college, and retire comfortably. And we know that that's not always the case. Or some doctors may tell each other that they make a lot of money on their vacation homes. We know that that's almost never the case. And some people steal from them in a criminal manner. So number 6, having a team of advisors that's going to make it more difficult for that to occur or less likely that that's going to occur can be important. And taking doctors through these principles, having a balanced life where their health is considered, their career is considered, the happiness of their family is considered. You're not going to have a successful medical practice if you don't have fundamentally successful physicians, nurse practitioners, and other people working in the practice. Remember all the kindergarten principles. And in particular, I like to say, and it's very true, if you think you need a large house to be happy, then you need a psychiatrist, not a realtor. That's really important because we see a lot of too big houses. So it's a big mistake not to engage in the proper process. What is the process? First of all, I know what I have. I know what my paperwork is. Secondly, I have the right advisors and they know what's going on. Third, I'm getting educated and I've been educated on what's important from a decision-making standpoint. I'm not just going with the flow. Fourth, my legal, my accounting, my tax, my financial advisors have customized my situation so it fits me well. Number 4, we review periodically. We maintain, we update, and we modify. And number 7, we live happily ever after. So many physicians are driving a car without knowing whether the brake will work, let alone whether the emergency brake will work. They go so fast and they're so busy, or they've gotten mediocre advice, and when bad things happen that would normally tilt the boat a little, they completely sink, go bankrupt, and have to start again, smarter but poorer. So there's Clearwater Beach. You don't see any boats because they all sank. You want to build a solid foundation. You don't see any sandcastles because they all got blown away by the wind. You don't see any doctors because they all have to work because they didn't save enough for retirement. Page 11. The most successful professionals, the most successful businesses have written verifiable goals. They look at them. They look at the obstacles. They come up with solutions to the obstacles, and they get to their goals. It's a good idea to ask your physician clients, what are your goals? Beyond surviving today and answering your voicemails and checking Facebook, what do you want to accomplish? Do you want to have a $20 million net worth so that you can retire? Well, if you're going to want to do that, you may have to work a little harder, a little bit more efficiently, maybe set up your own practice instead of work for somebody else. These goals go on, but they're important to have. Next, I think we all need to agree that our brains play a lot of tricks on us. There's a lot of self-deception. Your brain never admits it's wrong, and it rarely admits that it needs more information. If your brain gets a question, it just makes up an answer, and it tells you it's the right answer. This book, You Are Not So Smart, my wife Marcia bought it for me. I'm not sure why she chose the title, but when you read it, it's really interesting, all the different misconceptions that our brain will give us. So your physician clients don't really realize that they need to have plenty of liability insurance for their car driving, and that having a teenager drive their car is very dangerous, and that creditors don't always settle for policy limits in malpractice situations, etc. They're looking for us to give them that wisdom, and we need to educate them. We need to be more than just professionals who say, yes, you need a will, here's my cash register, ring, ring, thanks very much. How about if you own your assets jointly, it's harder for creditors to take them unless you're both sued, but if one of you dies, then it could go to the next spouse. Should you have a marital asset protection agreement? That type of thing. Have good advisors. Think it through. Now, there's a lot of structuring problems and misconceptions, and I thought I'd give you an example of how to do something right here. On slide 15, we have a doctor who sets up a new practice. She leaves her old practice, she sets up a new practice. She can own the new practice jointly as tenants by the entireties with her spouse if they live in Florida. Even if her spouse is not a physician, as long as the physician is a part owner, you can have ownership without having to register the entity under the Clinic Act. Does she want to own this as an S corporation, which owns the medical practice? Or, for more flexibility, she and her spouse can own an LLC taxed as an S corporation, which in turn owns an LLC, which I say here is disregarded with a tax ID number, which in turn owns and operates the medical practice. The advantage here is that the LLC at the bottom can get the tax ID number, own and operate the medical practice, and when she brings a new doctor in or a new investment partner, whatever it is, they can keep the LLC where it is. You can go to the right now. The new partner can set up a new S corporation, buy into the existing entity, which you show there at the bottom, which is taxed as a partnership. And this is a much better tax planning strategy than having two people in one S corporation, because now their relative income can be distributed to their separate S corps. It's much more flexible under the Stark law, which we'll mention later. It has nothing to do with nudity. And then they can each do their own tax planning without being concerned about each other's tax planning. So when you have a doctor who calls you and says, I want to set up a new practice, the first question is, will you possibly be adding partners in the future? And the second question is, who is your CPA, so that I can see if she agrees with this being a better strategy than starting the practice under the S corporation. If you start the practice under the S corporation, then it's very hard to move it out of the S corporation without causing tax, and you have to get a new tax ID number, new Medicare number, et cetera, causing you to need Excedrin. Now, page 16, you've got the medical practice in the middle right. It leases space from the building LLC, which is in a separate entity. It would be a mistake to have them in the same entity. And you see that this LLC taxed as an S corporation owns an LLC taxed, which is a medical practice. Separately, it owns an LLC that owns the furniture and equipment, which makes it much more difficult for a malpractice claimant to get hold of the furniture and equipment. Separately, it owns the doctor's car, so that it gets the write-off for owning the doctor's car, but if the doctor's or someone else driving her car is in an accident, you don't lose all the medical practice assets. And then separately, it may own the accounts receivable and any letters of protection, so that it would be more difficult for a creditor to reach them. We have something called the ELOPE system, E-L-O-P-E, which has to do with factoring accounts receivables within the family to save tax money. And then on the left, you've got the building LLC. If there's a big mortgage on the building, you could ask the LLC that owns the medical practice to guarantee that loan and pledge the medical practice assets as additional collateral for the loan, so that if the medical practice is sued for malpractice, which will often happen, and they don't settle for the limits, which also often happens, I'll testify to that, then the bank can swoop in and take the medical practice assets away before the plaintiff lawyer can in most situations. So have you discussed these planning items with your physician clients? And if not, when will you? Hopefully before they get sued or before they switch advisors. Page 17 is a typical medical practice family. You've got the S Corp on the left. You've got a trust for the children above to the right in green. It owns 2% of the building LLC. So if they get a judgment against the doctor and the doctor's spouse, they can't take away the control or their ownership of the building LLC. They only get something called a charging order, which isn't nearly as good as being able to take it over. So that helps to hold the creditors at bay in a very inexpensive way. Then you've got the medical practice LLC owned by the S Corp. So, and you've got the vehicle LLC. Let's go to page 18. Now here's the doctor and his spouse. I use some creative names, John Client and Jane Client. And you've got an irrevocable life insurance trust on the left, which is for the benefit of Jane and descendants. You would have John as the trustee if you're in Florida to satisfy the Clinic Act. There are ways to do that. John and Jane each have revocable trusts. You don't put any assets in the revocable trust of the doctor, please, because if you put an asset in the revocable trust, the creditors can pull it out just as easy as the client put it in. And that might even include the ownership of permanent life insurance and annuity contracts that would have been protected in the name of the doctor. Then you have their tenancy by the entirety's assets in green, which may include significant ownership of the practice, the medical practice. You want to make sure the titling's right. If the titling's wrong, then you can lose half of those assets if the doctor's sued. It's easy to get the titling wrong. Then you've got the building in blue with another owner. That might be the doctor's partner. And then you have the investments of the doctor and the spouse in a green on the far right-hand side. If you're green with envy, you can remember that. It's hard to get hold of these assets if you're a creditor. They're owned partly, this LLC is owned partly as tenants by the entireties. It's owned partly by the spouse's revocable trust. It's owned partly by the trust for children. If you find a way to get a judgment against both spouses, then you'd have charging order protection. The creditor can't reach in or take over control. They just get a lien against 98%, which is better than not being able to take, which is better than being able to take over control. If Jane dies, then 40% is owned of the LLC is owned by her revocable trust, which becomes irrevocable. It's held for the lifetime health, education, and maintenance of her husband. He could even remarry and not lose that 40%. For some clients, we put a lot more than 40% into the non-physician spouse's revocable trust, or we buy a lot of term life insurance on the non-physician spouse so that if she dies or he dies, the lost assets from loss of tenancy by the entirety status are replaced by a payment from the life insurance company into the Jane A client revocable trust. Yes, it's a mistake not to consider all of this structuring. And also, if it's a high-risk situation, you might have a significant portion of the investment LLC owned by an asset protection trust, which might be sited in Nevis, Alaska, Belize, if you like to visit Belize and dive at the one of the nicest reefs that's still around. That's worth considering. What if you're single? Well, if you're single, you should marry another physician, even wealthier than you, put all the assets in tenancy by the entireties, and then get divorced, and you'll come out ahead. If you don't want to use that strategy, we do have, as you see here on page 19, the homestead protected, IRA, 401k, annuity contracts, life insurance protected, revocable trust not protected, medical practice payable to wage account. In Florida, a physician who receives wages as a W-2 employee may have creditor protection for those wages if they go into a protected status. If the doctor owns his own medical practice, he should have an employment agreement and fixed periodic wages, which can go into a wage account or a variable annuity or a tenancy by the entireties account. Sometimes it's a mistake not to have that. We recommend a 20-year lease between the medical practice and an LLC that's protected from creditors. That way, if there's a violation of the lease because of the insolvency of the medical practice, 20 years rent comes due, and the building company has a good running start as it competes against the malpractice claimant, cross-collateralization of debt, separate asset protection trust that may be used to protect real estate, et cetera, et cetera. Page 20, I just want to remind you that fully 30 to 40% of the physician clients that have serious creditor protection problems in our office are from car accidents. And it's usually not the physician, it's usually a child who the physician signed for to be able to drive before age 18, or who is driving the physician's car. So there's a Forbes article. If you Google Forbes Gassman Parked, P-A-R-K-E-D, you'll see this article, and tell all your friends about it. But think about how the doctor owns the car. Certainly, hopefully not in joint names with a spouse. And if one spouse signed the child up to get their driver's license, then that spouse should own the car, not the other spouse that the child drives. Page 21, I have a slide for this. Run your business responsibly. Well, I was too tired. I didn't have time to hire a good office manager. I couldn't find a good office manager. My CPA was too busy. My lawyer was too busy. So I ran my office in a haphazard way, and I was so surprised when the government came in and locked me down and took my license away because I didn't realize that I wasn't following all the rules. We don't want that to be our client or our friend. It is not impossible, and it is not even that difficult to run a business responsibly like a business. Please don't be a house of cards. I will skip slide 22. Now I'm going to go to slide 23. We have 9 minutes remaining. That's known as 3/10 of a billable hour in my profession. Sorry we're not all on the beach. What's going out on the beach? Well, there's more people there, still no birds, a lot of little kids. There's a bird. Oh, that's a dog. Well, maybe she's not. Oh, you saw the bird. All right. Enough of a break. Let's go through the mistakes. There's 11 of them. It would be a mistake to not review them. Number one, failure to maintain independent professional advisors. Number two, not maintaining a medical law compliance program. Number three, improper or not enough malpractice insurance. Number four, no buy-sell shareholder or employment agreements to put standards against your partners. Number five, no proper casualty and liability insurance. Number six, the practice is not judgment-proof. If you get a judgment against it or a serious lawsuit, you have to worry about losing furniture, equipment, and accounts receivable. Number seven, your CPA did not theft-proof your financial operations, so you lost $250,000 before you even knew it. Number eight, greedy investment advisors. Number nine, unbalanced investment portfolios and decisions. Number 10, doing business with the wrong people, also known as jerks and thieves. Maybe a father-in-law too. Number 11, failure to pay attention to contracts with third parties. Let's go to number one. Number one, if you have good professional advisors, they can help guide you through avoiding 2 through 11. For most clients, to be candid, the most important professional for them is not their lawyer, not their psychiatrist, although they need both of us, but their CPA. CPAs have business sense, they have business information, they have the financial statements. And 20 years ago, the average client met with the average CPA 2-3 hours a year, twice or 3 or 4 times a year, and got some good business advice. And that, unfortunately, is much more rare. So one of the best pieces of advice I can give to a doctor who's listening to this webinar, sit down with your CPA, make a 1-hour appointment, make eye contact, say, hey, Floyd, what's important to me is that I'm making the right decisions in my practice, in my marketing, in my investments, in my legal compliance. If you were me, what would you be doing, and how can you please educate me? If the CPA wants nothing to do with that, then quite respectfully, I will say that's the wrong CPA. But a lot of CPAs are a little bit shy, and if 9 out of 10 clients are resistant to paying an hourly rate for advice, they're a little bit too bashful to push that on all their clients. So let them know you appreciate it. Be the lawyer. Now, I have significant bias here, so I'm not going to say so much, other than to tell you that a lot of people walk in my door and they clearly went to either no lawyer or they tried to do it online, legal Zoom malpracticeagainstmyself.com, or they got a lawyer who doesn't practice in their area. So let me tell you, if I have problems with my kidney, I'm going to go to a nephrologist. I'm not going to go to my friend from high school who's a dermatologist. But that's what doctors do all the time with lawyers. And lawyers can be generalists or specialists. And if you're watching this, you owe it to yourself to have a lawyer who represents a lot of physicians and knows what he or she is doing in that area. Again, sit down with the lawyer. I'd like to pay you for an hour of your time. What can you tell me to protect myself and to protect my family? What areas do you not handle? I have a big medical practice. Do you handle medical privacy? Do you handle Stark and anti-kickback law compliance? If not, who do you recommend? I trust you as my lawyer. I won't fire you if you admit what you don't know. Then the other advisors. And we'll be talking about greedy investment advisors because they're a threat to your wealth. Bankers can be very important, but don't think that they're in business because they love you only and want you to do well. Everyone is in business because they want to earn a reasonable living, or they want to earn more than a reasonable living, or because they have a loose screw. Most people who are charitable actually work for charities. So please give thought to who your advisors are, how they were chosen, and do they mean well for you? Do they care about you? You know, a lot of people go and get their asset protection done by these fly-by-night, quite candidly, organizations who go to doctor conferences and they speak, and they're not even lawyers licensed in the state. They grab as much money as they can, they do as little work as possible, and then we're left to pick up the pieces. If you have a good CPA, independent from the lawyer, and independent from the financial advisor, and somebody's getting out of line, that will usually be spotted by somebody else on the team. And that's a good reason to have independent people. I wouldn't use a law firm that was also my accounting firm, even if they were well qualified to do that. I wouldn't use a CPA to do my investments, even if the CPA is well qualified to do that, because I'd rather have an independent CPA who reviews my investments and tells me when I might be getting into trouble. Please keep in mind that whenever you deal with an advisor, there is a profit motive. The longer you sit in the conference room, the more money I make. The more little circles on your chart, the more money I make. Am I doing this to help you, or am I doing this to help myself? Especially with investment advisors, when you buy certain products such as life insurance, permanent life insurance, and annuities, they make more money. They make less money if you buy a stock or a bond and then you let it sit the way Warren Buffett says you should. So again, be thinking about what is the motive of who I am working for. Is it a healthy motive or is it an unhealthy motive? Go through the list of those people advising you. And don't trust people who don't have licenses. They almost always will get you into trouble. Isn't this a cheerful talk? It always makes me so happy. The reason it makes me happy is not the streak of sadism that you've just seen. It's the fact that if my clients follow the 11 warnings live reasonably, spend maybe 10 hours a year attending to this business, and earn more than they spend. They are guaranteed success based upon 65 years of history, Monte Carlo analysis with the stock market, how real estate has done in the last 65 years, and the experience of our clients who are reasonably careful and who have someone watching out for them. You see here on page 24, failure to maintain medical law compliance. I'm going to talk about that when we resume on the 27th of February. You can read about it in the outline. But if I had my own physician office, once a year I would hire a consultant to come in for one day to look at a few charts randomly, to look at our claims forms randomly, to look at our chart notes randomly, to look at our system for avoiding theft randomly, and to tell us at the end of the day what they advise. They will almost always find ways to help you make more money. They will almost always find ways to help you reduce risk. It's tax deductible, and it's, in my opinion, unwise not to have an annual checkup from a medical and business law standpoint. Okay, I was once told the most important thing if you want to be a successful speaker is to start on time and finish on time. I'm 1 minute late. I'm not going to charge you the extra 1/10 of an hour that would normally apply there. Please send me emails with questions, comments, and suggestions. Have a fantastic day. May the rest of your day be billable or on the beach. Those Canadians are having a great time. Thank you very much, and thanks for all you do for others. It's important to do the right thing, do the right thing for your clients, for your family, for your staff members, and for yourself. Thanks again. Bye.